Friends, I don't need to introduce myself anymore. Thank you for the introduction. And let me jump into the topic of intellectual property for small to medium enterprises. So, this is a myth that is about 400 years old, that intellectual property was protected by Shah Jahan. When a beautiful building like this was created, he wanted to make sure that his architects wouldn't go somewhere and build something as beautiful as this in a different place. And similar cultures, similar ideas exist in different cultures too. So this was IP protection 400 years ago. But again, it's a myth, so there are stories about this in different cultures. So fast forward 400 years, and this is what we have now. So to protect intellectual property, we have these four different vehicles for protection, and these protection also goes hand in hand with innovation. So as the talk progresses, you will see how innovation matches intellectual property, and each of them help each other to grow within a country, within an organization. And so here are the typical intellectual property innovation tools that we have, which are basically trademarks. And you know how important it is to protect a business's trademarks, how one can recognize a product or differentiate a product or a service from an organization. And that's what trademark gives you. Copyrights, we're all aware of copyrights, both software copyrights as well as artistic copyrights, books, movies, music. Trade secrets is another important way of protecting your intellectual property. And that's basically Coca-Cola formula, for example, how that has been protected for hundreds of years in making sure that no one copies the secret formula for that particular product. And then you have patents, which basically protects the product as well as the processes associated with your businesses that can be protected. So depending on where your business is, you have various different methods of protecting your intellectual property. So here are four words we always hear about: innovation, invention, and intellectual property. So let's define what innovation is. So basically an innovation is a process of taking an idea from your mind or from the company's mind and bringing it into the market. So basically a series of inventions will bring forth a product or a process to market. So basically this series of inventions is a method of solving a technical problem. That's what an invention is. And also an invention is sometimes a discovery of something brand new. Now, of course, this happens a little more rare, but then what happens more frequently is inventions for specific technical problems. When an engineer or a person solves a technical problem, that is captured as an invention. Then the exclusive rights that an invention owner, whether it's an assignee as a company or an individual, has is the exclusive rights on those inventions. That is what intellectual property is. And this is granted through patents, trade secrets, and various other methods of capturing and protecting your intellectual property rights. So now IP is found at various levels. So now IP savvy companies begin with ideas, capture the intellectual property before they talk to the outside world. But once the intellectual property has been captured, various levels within the company, still intellectual property can be generated and can be captured. So you have to have a method of observing your intellectual property as the product develops, as your company develops, and a person who can, or person or a group that can capture innovation at different levels, even after the product has been launched sometimes. You have to make certain changes, and those changes to your products can be captured even after the product is out there. Although there are time limits on how long the product is out there, or the extension of the product is out there, and how long you're allowed to capture the intellectual property. And there are some guidelines on that in the future slides. So as this particular topic, which I was told was more interesting to this crowd, is basically how do we capture IP for small to medium enterprises. And when I say small, it does include startups and incubators, which help small companies develop their intellectual property and develop their products. And just as a note, all that I'm talking over here, including the slides and the description, I would be distributing a pamphlet when you leave. So if you do not want to take notes, that's fine. I'll have that distributed after the talk. So predominantly small to medium enterprises are understaffed, right? So basically they are trying to come up with a product. Their concentration is on the product and on their methods of marketing the product and receiving venture capital if they need to have venture capital. And so they're concentrating on those aspects of it. So they are pretty much understaffed. They often are in a risky position because they don't have professional advice, because for one thing they don't have the time, nor do they have the money and the resources to get professional advice. Most of them lack professional training within intellectual property, because it is an abstract field, as Mono had just mentioned. And invariably, they handicap themselves into a bad position as time goes along, because they have not done the right things at the right time while the company was developing. So typically, a patent, a single patent, the life cycle cost for that single patent can be about $125,000 per patent. And now when I'm talking $125,000, this is for the life of the patent. So you begin prosecution of the patent, you're paying an attorney doing that. Then you start paying, once you get your patent, then you start paying for the maintenance of the patent in the country of your choice. And then the decision to make the patent an international patent, so you choose the countries that you have to, you pick the countries that you want your protection in, because patents are only country specific. If you have a patent in the US, it will not work in Canada, it will not work in Mexico or any other country. So you have to have country specific protection. So to make that decision of when you should apply, what kind of prosecution you want, how fast you want it to be prosecuted, when do you need, well, once it's issued, when do you need for it to be maintained, and when do you need to be abandoned? So these are decisions you have to take. And even these decisions are even taken by large companies, because the large companies, if one patent costs this much, and if companies like, IBM has 40,000 patents, Microsoft has 26,000 patents. So when you multiply that number with this, it's a huge number to maintain. So these strategies of how to maintain and how to manage the patent portfolio is important even for large companies. And they have a staff, and they are invariably in a better position than small to medium companies to maintain their patent portfolio. So for smaller companies, you have many different options. So one of them is something called provisional patents. So provisional is basically, you come up with a concept, you want to now talk to the outside world, you want to have a press conference, you want to be in a exposition to talk about your product, but you still want protection, but you don't want to spend the high amount of money that is required, time and money that's required for a full-fledged patent. You can apply for a provisional patent as a small to medium enterprise, and that's less than $200. So basically, you can apply for a provisional with just basically your PowerPoint of what your product is, with a cover letter, and you can do it basically yourself. You don't even need an attorney to do that. You have to be a little careful because you have to make sure that your product, that your provisional patent application should cover all aspects of your product, not a narrow product. You cannot apply for a patent for a black device with a green button with two white left and right buttons. So if you do that, then yes, you might get a patent, but then you will only be able to protect this device versus a communication device talking wirelessly to a computing device to allow interaction with a presentation. Now, suddenly now you have taken your narrow definition of a provisional patent to a broader version. You might not get that patent because that's maybe too broad, but then that's what's needed to apply for the provisional. Then you have 1 year from the time you apply for the patent, provisional patent, to convert that into a full-fledged non-provisional patent application. So that is something which is very much affordable, so that within that 1 year, as a small company, you will know if the product is worthwhile to go for a full-fledged patent or not. Or if you want to drop it, the moment you drop and not convert it, no one in the world will know that application. It gets destroyed at the USPTO or any other country that you're applying it, and it will not become public anymore. So it will be as good as a trade secret at that point. Now, the second one could be defensive publication. So basically, you come up with an idea, you do your marketing, you figure out that it's not possible to productize it and market it at this particular moment, and you want to drop that idea. But you want to make sure that no one else comes with that idea later on and stops you from practicing that product at a later stage. So what you do is you take your product and apply for a defensive publication. So there are companies or websites, IBM is one of them, where you submit it and then it becomes public knowledge. So no one else can get a patent on it going forward, nor will you. And then the other one is a trade secret, so basically keeping it as a trade secret, and there are procedures that are needed, how you keep something a trade secret. And then you also have methods of strategic abandonment. So whether you applied for it, you've gotten the patent, now 3 years down the line, you need to make a huge payment, a maintenance payment up to 3.5 years of $20,000, $30,000, and nothing has happened in the 3 years with that product, and it's a time to abandon it. So there are times when you should decide it needs to be abandoned. So here are about 10 top things. I'll just let you glance through it. Don't read it all through because I'll go through each one of them. And top things that an SME should know about intellectual property. So the first one is treating IP as your friend. So basically, IP was created. I mean, you must have heard in the press and the pros and cons of intellectual property. So there's a huge, not huge, there's a considerable amount of people who hate intellectual property, and they think that it is against innovation, it is against small companies, and it is against the growth of a country's GDP. So there's a faction of those. So listen to them, but this is a fact that intellectual property has helped countries grow their GDP tremendous time by increasing innovation and intellectual property rights, and that does increase the GDP. And there's one good example, and that's United States of America, which has used that, and that model is being used all around the countries. And countries that are not doing it are either suffering right now or will be suffering from growth in the near future. So don't be fooled about the misinformation and horror stories that we hear from. Develop an understanding of what IP is, what are the different options, what are the costs associated with different options, and then bring in those, either the experts or the attorneys, So the attorneys are needed at a later stage when prosecution begins, when litigation happens. Those are the bad things when litigation happens. But then before the prosecution, business issues for the organization, for your company, needs to be dealt with by you, and then planning has to happen with regards to that. So again, as we spoke, there are various different vehicles for intellectual property. Patents is the one that we keep going back to patents because that protects the major part of your product processes and your company. But there are other aspects of that, your designs. So there's something called design patent and utility patents. So the look and feel of this is a design patent. And the functionality of how this interacts and what happens when I press a button is a utility patent. So you have utility patents, you have design patents, and you have copyrights. So in some cases, you cannot apply for a patent. You have a software, you cannot apply for a software patent. But a software patent associated with the hardware in a business method environment is patentable. But just a software is not patentable. You just have a software, all you can do is copyright the software. That's where you put the copyright notices, where if you see your code in a different establishment, you can basically go to court and stop them from using your code, or even better, pay you a royalty for using your code. So it's not always litigation that's needed. There could be positive aspects of intellectual property rights too. So educate yourself. I mean, this is the time if you have small companies and if you're advising small companies, this is the time. Educate yourself. A lot of information is available free of charge. So educate yourself from where you stand, what are the different comprehensive set of options that are available, and be ready when the time comes to make that decision on how you protect your company. So here's a list of places where you can find lots of searchable databases that are available. USPTO just recently, yesterday, came up with a new website which allows you to graphically search for landscapes and within the patent field, depending on the topic you're interested in. So there's a lot of information available out there, and then make sure that you look it up and educate yourself on the benefits of intellectual property for your company. So intellectual property also creates obligations for your company and yourself too. In this issue, if you get a patent, you basically get the right of stopping others from using your patent. But it does not give you the right to build your product. So you get the difference. When you get a patent, it's a negative right. It's not the right for others, for you to practice your product. It's a negative right. Basically stops others from making, using, selling, exporting, or importing your patentable concept. Now, if you really want to practice your product, you might have to go. I might be going a little ahead. The slides are there, but let me go ahead and finish my thought process. Is if you want to practice and have the freedom to practice your product, you might have to get a patent from someone else or license it from someone else to practice your own product. That's the difference between what patent rights are, which is a negative right. It stops others but doesn't allow you to practice your own concept or product. And again, keep in mind that you're coming up with a product, you'll have a very good example or research done to make sure that who your competitors are. But also remember that in the patent arena, your competitors might not be the ones that you really think of. They may be, as you can see, UPS probably should only worry about FedEx and DHL and USPS, right? But not anymore. Now there are non-traditional competitors, like Amazon, Google, Uber, and another 20 more I can talk about just in the logistics space. So these are non-traditional competitors. So similar, when you have a small company that you're starting, keep track of your main competitors on what their product placement is, what their marketing is, what their pricing is, but also make sure that you look at your non-traditional competitors. And there are methods of looking at it. Here we know the big ones, the Amazons, the Googles, the Ubers. You have a small company or unique product. How would you find out companies that are Amazons and the Ubers of your product? IP searches, IP landscape searches will bring that information out and give you that capability to define who those non-traditional competitors are. So there's a methodology for extracting that non-competitor, non-traditional competitors within your field. And then as we spoke, we still have to make sure you have to decide if you're planning to develop your product or services, which country would you like to use it in. So you'll have to do quite a bit of research within the country that you are working in on what kind of products are available in that country, what kind of IPR, intellectual property rights, are available in that country. Should you apply for those patents within those countries? Is it worthwhile? What's the ROI? And what are the risks of not applying in the country? So you'll have to make that decision with business development, marketing teams, and your legal team. When you get to a stage where you are going into a foreign country and you need IP protection within those countries. And here's something to think about, the window of opportunity. So you have a concept, you cannot keep it in your head. You need to be talking to people. You need to be pitching in front of various different, whether it is for funding, whether it's for recognition, whether it is for M&A, whether it's for joint ventures, you need to be pitching. So at what stage is it comfortable for you to be talking to folks but not lose the concept and your secret sauce that you have developed? So there are different methods of doing that. One is you can have NDAs with folks, and also you have to be careful that even if you think that you have a head start, you start talking to folks out in conferences and expositions. The moment you make a public announcement of your concept, you have exactly 1 year, 365 days from that date to apply for a patent. Otherwise, you lose that. That becomes public domain. So on the 366th day, it's public domain. So you have no right on that concept. And anyone out there can take it, develop it, and stop you from developing it too. Basically, they can get the rights on that. So there's a critical 1 year agreement. Unless you have an NDA with a joint venture or an M&A, when you have an NDA, that 1 year window can be extended for a longer period of time. Yes?
So if they can stop you, then it's not public domain, right? Public means anybody can use.
Oh, that is correct. That is correct. So when it becomes a public domain, you have no right to stop them. They have no right to stop you. But they can pick up that concept, add enough materials around it, and now come back and sue you and stop you from that product if you have gone down that path. So that danger is always there. So rather than risk that danger, it's better to protect yourself before you speak in public. And again, this is what I was talking about. I was a little ahead of my slide over here, that patents are negative rights. It only enables you to prevent others from practicing your invention. And that is why it is important for you to have a strategy of what you want to do with the patent. Because building up a patent portfolio will only tell your investor that others cannot practice these patents. But it does not allow you to practice or grow your product in different directions based on those patents. You need to make sure that you might have to get patents from other folks or license from other folks to get the freedom to operate within those product domains.
This is not out of fear that somebody else may have patented and it's overlapping.
So it is basically somebody who's already patented it. So that's where you have to do a substantial amount of search to make sure that, for one thing, you have your patents in there to stop them from working, but then there are some people over here who have patents that can stop you from. So before that happens, there are two things you can do. You can basically read all their patents because it's public knowledge. You can design your product around each of those patents. Or if it is very difficult to do that, you can go and talk to 3 or 4 of the important ones and say, hey, I'm developing this product, looks like you license me your product for X amount of royalty. Or could we work together? So those are the aspects that one can do, knowing what the landscape looks like. Knowing the landscape is very important in this situation. So, we always think about litigation. That's the first thing that comes to mind. Either the fear, or if we have a portfolio, the right to go and litigate someone. But as you can see, there are many different avenues for revenue generation or monetization based on, you can have many deals. There could be a one-time license, there could be not to sue, there could be a cross-license, because they might have 3 patents, you might have 4 patents. Together, if you have a cross-license, you can still work on the products and get a wider, broader protection for our intellectual assets. And also something that one should know, the majority of IP lawsuits are settled out of court in the end anyway. So one should not have the fear, or one should not be overzealous in suing somebody, because this is the story behind that. So roughly in the last decade, every year, average, there are about 3,000 lawsuits that are assessed by a patent owner. Out of that, 90% of these lawsuits are abandoned or settled outside. 300 that remain, 2/3 of them never go to trial, but they go to the court or they are thrown out by the judge, basically because the patent is invalid or the IP rights of the individual is overboard. So it is 2/3 are thrown out. So that leaves about 100 patent infringement per year, and this is that go to trial. And this is basically an average in the last 10 years. So out of 2 million active patents in the US, 100 patents is all that you see. So basically the Wall Street Journal headings that you see are those 100 patents and the results of those 100 lawsuits that actually have gone to trial. And the news about that is what you read. So the key takeaway is litigation is not the only method. There are many other things that can be done way before litigation happens when you have a patent portfolio. Coming to the last point over here, having an IP strategy in your mind, just like you have your marketing strategy, you have your business strategy, you have your financial strategy within your organization, having an IP strategy is important. And it will always be much cheaper to have that and check that box as you're moving along the process of building your company. That's much cheaper than doing it in a proactive way than in a reactive way, which most of the companies do get into that situations where they have to be reactive and lots of mistakes are made when you're in a reactive mode than in a proactive. So here are some best practices that have been collected through time working with many different clients. And so this basically gives you, I'll let you go read through it, so then we'll go through each one of them.
So we have been discussing about patents. Do we have like on the trademarks? Like because I have seen my company got impacted because of that. As somebody trademarked like a very common word, which was the word flow. So is it like is it possible to trademark something which is as
Yeah.
simple word as flow?
No, that's for one thing is some mistake has happened. Common terms cannot be trademarked, but you can apply for it. It could be an examiner sitting in Washington D.C. in Alexandria who looks at it and says, "We do a search and they can clear it or issue it." So that organization will get that, but then if it is a common word, it can be contested, and then you eventually they could lose that particular trademark. So that's a dual reason not to have common words as trademarks, have unique words that can associate the product to the name versus a generic term where you will not get the benefit of the trademark when it's a generic.
Okay.
So these are the seven different. How am I doing on time?
Yes. Yeah. Good. Good.
All right. Okay.
Yeah. Interesting.
Another 10-15 minutes.
Yeah. We can take more. Yeah.
Okay. So one of the things is seeking education. It applies more to the management team as well as employees. So now we're talking of a small company, 20, 30 people within the company. And so seeking that education of intellectual property all the way from the top management down to your engineers and your developers and your marketing folks and sales folks too. Having that ability to tell them what the power of IP is for your organization. And basically it will give them the power to, in various business deals, in negotiations, in positioning, value creation. For example, you have 4 patents on belt diverters, and you're talking to Siemens, who has 10,000 patents. But you have 4 patents which are critical, and you are buying a product from Siemens, which costs $100,000 a piece. But those 4 patents could be used as leverage for discounting that particular product. So there are many different ways of negotiating a deal with intellectual property. So, and then providing the how-to for engineers. So if you know that most of the engineers, when they solve a problem, they just move on, because that's what they're trained to do. They get a problem, they solve it, and they move on to the next. And this happens to me. I'm bringing engineers because I'm an engineer, and in R&D, basically that's what happens. But I'm sure it happens in different fields too. So reminding engineers that that simple thing that you worked on and you moved on to the next one, to remind them that yes, this was not available. I did something unique to solve that technical problem. Just having that ability and training these engineers to stop at that moment, talk to a IP coordinator within the organization to basically say, let's capture that. Let's capture that in a notebook, in a document, in an email, and come back to it at a later time. But having that ability to train the engineers, to motivate those engineers to keep track of the creative invention, the creative problem solving that they have, and then enabling them to conduct their own IP research. So basically, if they thought of, they solved a problem, but that problem could have been solved in 10 different places. They just didn't know about it. But then how would they find out that that is unique? Give them the ability to look up a free database and see if something is available out there, or on the patent side. On the product side, it might be difficult because it might be embedded within the product. You wouldn't know that that particular concept is in the product. So having a mentor within an organization to to basically remind engineers and staff and management that there has to be some methodic invention capture process. And then once that is done, then your legal team within your organization or your outside counsel will do the others, the drafting of the invention, the application process, the prosecution process. That is done outside of the engineer's time.
Okay.
Yes.
There is a flip side to this one as we talk about plagiarism being taken very lightly in India compared to here. You know, what may be considered as plagiarism here in India, probably a student may tolerate it by when they copy code too much, so to speak.
Yes.
I'm using that as an example.
Okay.
A software engineer, by the same token, here it is more of a documenting and getting patent that you're talking about. What if they are copying from other people because they browsed in the web and found something? How do you train them so that they don't do things that can get you into trouble?
Absolutely. For example, open source is one very good example. Right? And it's great for people to start off taking open source. It is similar to that. So it is out there, you bring it in, and even if it is copyrighted, somebody has taken the code and thrown it on the web, and you didn't know it, you just brought it in and put it in your code and made it work. So large organizations, the way they do that is they put very strict rules, to include that they will be fired from the job if they bring code from anywhere and embed it into the code. That's number one. Second, even with that policing, there's a company called Black Duck, and there are some companies like that. What that does is you submit your whole code base to them. They go through it, they search the web, and then they do a match, even if there is a level, but there's not a 100% match. They have a method of bringing down from 100 to 75% match of what's out there, and it highlights the pilfered code that an organization see, and then basically cut it out and write their own code to replace that. So even with rules and regulations and fear of losing the job in large organizations, people do that, because if something can be done in 5 minutes versus 10 days, why wouldn't they do that? But there are methods to catch them, to automated searching tools. So here is another thing that in your company, when you're seeking to say that the internal and the external relationships, which are vital when you're growing your company, and this is basically employee agreements. So having proper employee agreements is crucial if your company is based on innovative IP-based company, where having a non-compete provision within your agreement, but again, making sure that this is something that the attorney would advise you, making sure there is both time and jurisdiction restrictions, because without those two, having a non-compete is as good as, is not worth the paper it's printed on. So making sure that you have time and jurisdiction restrictions, having non-disclosure provisions, making sure that your employee working with you cannot go and work for your competitor and take your ideas and concepts, your code, your business contacts, to make sure that, and the right in work product, basically. So basically when your employee or your consultant or your contractor is working on the product and you're paying for that, making sure the right in work product is assigned to your company before the person starts working for the company. So having a ironclad employee agreement is important when you start growing your company. And then having a similar type of supplier and vendor agreements too. So basically when you're talking about supplier and vendors, you are exposing your company quite a bit, because you are telling your supplier what you need and your vendors exactly what you need to plug into your product. So you have to make sure that your suppliers cannot take that information, because they have to be educated, because otherwise they'll be supplying you the wrong products, and or you'll have to spend more time integrating supplier's product into your system. So if you want the right product, you need to talk about it pretty openly to make sure that the specs are right, accept the product into your environment. And so making sure that the supplier and vendor agreements are ironclad before you start exposing your system to them. Again, this might sound like a advertisement, but not, because it is very important to get that advice, that strategy advice, from the person who's outside the company, because there's many times within the company you are kind of there's an opaqueness to your decision making in these important, risky, complex issues. So having an advice, or even being part of a group of people, like Richard, what you're talking about, when you mentor, when you talk to folks, being part of the group which advises people to do and have the knowledge of risk mitigants, risk mitigation with intellectual property is something one should do. Having primarily the map of the business that you're in, and the landscape, the IP landscape, having a method to match your business issues and your IP issues, and having either an entity within your company understand those, or taking advice from an outside agency that will do that match between your business needs and your IP needs within the organization. And then have some kind of a facilitated session between your business leaders and your marketeers, your engineers, and your legal counsel. So you have to have inputs from all of them. This is not a silo program. If it becomes a silo program, it defeats the whole purpose of having an IP strategy within your company. And hence, in many companies, large companies, or Fortune 500 companies, they have entities that are outside the legal, outside business, outside R&D, reporting up to the management committee. And that's the kind of environment which is ideal for the best advice that an IP group can give within a company. And again, if that individual or that group has the power from the senior management to talk between the different organizations, not become a silo. And I'm trying to reflect on where I came from at UPS, where there were silos in each of the departments. So having a group outside where I came from, an outside group, helped quite a bit in those situations. So this is another point where having an ability for potential inventions, they can either be produced like publications. See, if you're working for a research university, you're more leaning towards publication. You don't care too much about the patent. But then within the university, there is a technology transfer department, which is not interested in publication. Yes, it is interested in publication after a patent application has been applied. So they would like you to wait. But so that's a chicken and egg problem for researchers within the university environment sometimes, where you need publications to make sure that it's peer reviewed and you can move on to the next step. And the technology transfer department needs that 1 year window before you start talking in conferences and before a patent application can be filed. So there's an issue with that. That has to be dealt with in organizations and even in universities and in companies to make sure that you make a decision well ahead of time. And then once you become sophisticated enough to start generating multiple number of patents within the organizations, within different product lines or different sub-product lines, then you have to make sure that your engineers and your outside counsel, which most of them would be an outside counsel because if you're small, you cannot afford to hire an attorney at $600 an hour to be paid within your organization. You will be going to an outside counsel. So when you're going to the outside counsel, you have to make sure that there's someone within your organization who can basically bring all the information together in one spot before you hand it over to the outside counsel. Otherwise, at $600 an hour, it's going to be pretty expensive to maintain an IP program within your organization. So to do that, how do you do that? How to go about documenting your invention? How to make sure that the technical disclosures that have been made are as broad as possible. So as I talked to you before, you don't want to apply for a patent on a black device with a red button and two white buttons. You want to have a broad enough. So educating that to make sure that all of that broad description is there before you go and talk to your outside counsel would be beneficial. And then within your senior management, you have to make sure that your senior management does understand that inventions, how they assist in different ways. It's not only for protection, it's not for stopping others, it is not only for, it's also for developing partnerships, joint development, making sure that you have joint ventures, and then how, and then defining it at least in your mind and having a plan on what do you do with your competitors, with the portfolio that you have. Because without that plan, having a portfolio is completely useless. You can talk about it. Sometimes it's a big ego thing for companies. They have 10,000 patents, 8,000 patents, 3,000 patents. But if you don't have a plan on what you want to do with that, and if you're not strategically managing it, it's basically a wasted effort at that time. Maybe repeating myself over here. So here are the two different alternative approaches. You decided that either for cost reasons or for not pursuing that particular product, you are planning to abandon it, but you have done enough work on it. So either hold it as a trade secret, maybe 3 years from now it will make sense. Maybe 3 years from now you'll get money to do something with it. Maybe 3 years from now the technology would have caught up to your idea. So keep that as a trade secret. Or if you think you want to make sure that no one else will get a patent in that, do a defensive publication. That way it will stop others from pursuing those products moving forward. So now this is more at a later stage. Now you're having a patent portfolio, you started talking to your outside counsel, and sometimes you might have grown to a larger company, you might have an inside counsel, and you're now making sure how your patents are written. Quantity versus quality. So again, having 200 patents, poor quality beats having 2 patents with good quality product. So having training your outside counsel and your engineers to make sure that your patents are high in quality. There are methodologies that are in place that can make sure that your patents are high in quality going forward. And in the end, I mean, all this is basically the end for a small company with any kind of exit strategy to make sure that you're building value, and for your next round of investment or for your next level of commercialization, you're making sure that you have a IP story. Just like you have a marketing story, you have a financial story. When you start talking about your next level, you have an IP story basically. So create that IP story, you have to do all these things that we spoke about in the last 1 hour, and make sure that everything is captured in a concise way that can be presented during any of these pitches that you would do going forward within the company. So in conclusion, these are the 7 best practices that you just heard are ways of affecting a cost-effective IP protection given the small companies' limited resources. Further, these practices also designed to maximize return on investment. So you've basically spent a lot of money to make sure that there is an ROI on what you've done. And the combined effort to optimize, so cost effective and ROI, you have to basically optimize between those two. Be both cost effective and have a decent return on investment, so that your business proposition is improved, as well as you decrease the risk for doing business